2842 of 2024. Section 125 CRPC overview. Section 125 CRPC mandates maintenance for wives, children and parents if the person with sufficient means neglects or refuses to maintain them. Defines wife to include divorced women who have not remarried. Constitutional context. Section 125 CRPC is a measure of social justice positively aligned with Article 15 Clause 1 and 15 Clause 3 and Article 39E of the Constitution, ensuring non-discrimination and special provisions for women and children. It aims to provide financial support and prevent destitution and vagrancy among divorced women, Muslim women. Now, rights of a divorced Muslim woman. Divorced women who haven't remarried and are entitled to maintenance similar to wives under Section 125 CRPC of all other religions. Maintenance under this section is intended to prevent vagrancy and ensure a basic standard of living, independence from other laws. The right to maintenance under Section 125 CRPC is independent of other maintenance provisions such as those in Protection of Women from a Domestic Violence Act 2005. The 1986 Act, Muslim Women Divorcees Act, does not dilute the purpose of Section 125 CRPC. Judicial interpretation. Historical judgments, example Jagir Kaur versus Jaswant Singh, Bhagwan Dutt versus Kamala Devi, emphasize the social purpose of maintenance laws, aiming to prevent destitution and provide basic needs. Role of maintenance. Maintenance orders under Section 125 CRPC are rehabilitative, not punitive, aiming to support women financially. Acknowledges the economic dependence of married and divorced women, particularly those who have sacrificed employment opportunities for family responsibilities. Constitutional imperative. Ensuring maintenance for divorced women without an independent income is a constitutional imperative to protect vulnerable women from financial instability. Conclusion. The court upheld the Telangana High Court's decision emphasizing that Section 125 CRPC serves as a crucial social justice mechanism for ensuring maintenance for wives and divorced women irrespective of other personal laws. Context and balance in a maintenance law. The law of maintenance aims to balance a husband's duty towards his wife and children with the need to avoid causing him undue financial hardship, as established in Bhuvan Mohan Singh versus Meena 2015 and Reema Salkan versus Sumer Singh Salkan 2019. Adequacy and sufficiency of maintenance. Maintenance must be sufficient for the wife to live with dignity, transcending personal laws, as upheld by the courts. Key judgments and provisions. 1. Kunhi Moin versus Pattumma 1976. Kerala High Court dismissed a Muslim husband's challenge to Section 125 CRPC, emphasizing its role in social welfare and reform. Bai Tahira versus Ali Hussain Fida Ali Chotia 1979. The Supreme Court ruled that a divorced wife in destitution is entitled to maintenance under Section 125, reflecting the Constitution's commitment to social justice. Fazlun B versus K. Khadar Wali 1980 and Shah Bano Begum 1985 affirmed that the Section 125 applies to Muslim women requiring husbands to provide maintenance post-divorce if the ex-wife cannot maintain herself. Then Muslim Women Protection of Rights and Divorce Act 1986. This act was enacted following the Shah Bano judgment of Supreme Court to clarify maintenance rights for divorced Muslim women. It specifies maintenance within the iddat period, maintenance for children up to 2 years after birth, meher or dower and properties given during the marriage to be returned to the wife, maintenance by relatives or the state Waqf board if no relatives can support her. Then came the judgment of Daniel Latifi versus Union of India, in which 2001 the Supreme Court reiterated that a divorced Muslim woman can seek maintenance under Section 125 CRPC if she is unable to maintain herself post iddat period. The court highlighted the disparity between men and women in society, emphasizing the need for fair maintenance to uphold basic human rights and social justice. This summary highlights key legal principles and case laws related to maintenance in India. Context. The Constitutional Bench upheld the provisions of Muslim Women Protection of Rights on Divorce Act 1986 in Daniel Latifi case, clarifying the obligations of Muslim husbands towards their divorced wives. Key points. Maintenance beyond iddat. A Muslim husband must make reasonable and fair provision for the future of his divorced wife for her entire life, provided she doesn't remarry, including maintenance beyond the iddat period, waiting period following the divorce, that is iddat. This provision must be made within the iddat period as per Section 31A of the 86 Act. Liability is not limited to the requirements of the iddat period. The liability of a Muslim husband to pay maintenance under Section 31A is not confined to the requirements of the wife during the iddat period, but they cover her requirements for the entire life. Post-iddat maintenance. A divorced Muslim woman who hasn't remarried and cannot maintain herself after the iddat period can claim maintenance from her relatives or, if they are unable, from the state Waqf board. Constitutional validity. The provisions of the 1986 Act do not violate Article 14, 15 and 21 of the Indian Constitution. Interpretation of the 86 Act. Not to undermine the Shah Bano case. The 1986 Act was not intended to nullify the effect of Shah Bano judgment, but to codify and regulate obligations due to Muslim women divorcees outside the scope of Section 125 CRPC. For that, you have to refer to the objects of the 1986 Act. Next, maintenance obligation. The husband's obligation to pay maintenance is for the duration of the iddat period, after which the responsibility shifts to women's relatives. If no relatives can support her, State Waqf Board steps in. That is view of one of the High Courts. Parliament's intention. Parliament intended that a divorced woman should have sufficient means of livelihood after divorce. The husband's obligation includes considering future needs and making advance arrangements for maintenance. Interaction with Section 125 CRPC. Non-obstante clause. Section 31 of the 1986 Act begins with a non-obstante clause, meaning it overrides other laws in case of conflict. That is, only in case of conflict. This clause ensures the rights under 1986 Act are in addition to and not a substitute for the rights under Section 125 CRPC. There is no bar on Section 125 CRPC. The 1986 Act does not bar a divorced Muslim woman from seeking maintenance under Section 125 CRPC. The intent is to enhance, not restrict her rights. Legislative intent and judicial interpretation. Judicial reasoning. Courts have interpreted the 86 Act purposively to ensure it does not deny justice to the divorced Muslim woman. The rights under the Act are seen as additional to those under Section 125 of the CRPC. Option for divorced Muslim woman. Divorced Muslim women can seek maintenance either under the 86 Act or under Section 125 of the CRPC. The courts must balance the amounts awarded under both provisions. The 86 Act provides additional rights for the divorced Muslim woman without restricting their right to seek maintenance under 125 CRPC. The court ensures these provisions work harmoniously to protect the dignity and livelihood of the divorced Muslim woman. The Appellant's Counsel, Sri Khadri, Senior Counsel, argued that the Parliament intended the 86 Act to override the secular law on maintenance under Section 125 to 128 CRPC. Section 5 and 7 of the 86 Act provide that a divorced Muslim woman and her former husband can choose to be governed by the CRPC provisions on maintenance through a written declaration before filing the first plaint. Section 7 ensures that any pending applications under the CRPC at the time of the Act commencement would be disposed of according to the 1986 Act. The court noted, however, that Section 5 offers an optional remedy, not optimal remedy or only remedy. It is an optional remedy under the CRPC. And Section 7, a transitional provision, does not abrogate a Muslim woman's right to claim maintenance under the CRPC. The court in Daniel Latifi emphasized that Muslim women should not be deprived of protection equivalent to non-Muslim women under Section 125 of CRPC, ensuring the right to live with dignity under Article 21 of the Constitution. The 1986 Act was upheld as constitutional by interpreting it to mandate the provision and maintenance within the iddat period but not limited to it. The court reiterated that the 1986 Act is a social welfare legislation providing additional rights and not taking away existing rights under personal law or Section 125 of CRPC. The 3-month time limit for disposing of applications under 86 Act ensures speedy justice, aligning with the aim of women's welfare and social security. The court concluded that a divorced Muslim woman is entitled to maintenance under CRPC regardless of personal law, and remarriage does not nullify her claim to a just settlement under the 86 Act. Access to justice. The interpretation of Section 3 of the Muslim Women Protection of Rights and Divorce Act 1986 should promote access to justice and gender equality. A narrow or a technical interpretation would undermine those goals and the constitutional right of Muslim divorced women to maintenance. The court emphasizes that maintenance should be adequate, not minimal, as it is a component of gender equality but not charity. Maintenance rights. Divorced Muslim women can seek maintenance under Section 125 of the Code of CRPC despite the 1986 Act. An application under Section 125 CRPC does not conflict with application under Section 3 of 1986 Act, as they serve different purposes and one does not replace the other. Jurisdictional issue. In Rana Nahid versus Sahidul Haq Chishti, Supreme Court affirmed that family courts do not have jurisdiction to handle applications under Section 3 of the 86 Act. This must be done by a magistrate. However, there was a difference of opinion and ultimately the matter was referred to a larger bench without resolution. Gender equality and human rights. The court acknowledged international human rights principles such as those in CEDAW, CEDAW, emphasizing that Muslim women should not receive lesser protection compared to other women. The 1986 Act should be interpreted in a way that benefits Muslim women, consistent with the international human rights commitments. Inclusivity. Divorced Muslim women should not face disparities in maintenance based on the law under which they were married or divorced. All divorced Muslim women are entitled to seek maintenance under Section 125 CRPC. Maintenance period. Under the 1986 Act, payment of maintenance is limited to that period, but the requirement is for the entire life. Whereas under Section 125 CRPC, payment itself continues as long as the woman remains unmarried and needs support. Children's maintenance. 1986 Act limits maintenance for children up to 2 years after their birth, while Section 125 CRPC mandates maintenance until they reach adulthood and majority. So that is much more beneficial for children. Amendments and benefits. The 2001 amendment to Section 125 CRPC removed the maintenance cap, making it more beneficial compared to the 1986 Act. Earlier it was 500 limit was there, now 500 limit has been removed in 2001. Concurrent application. A divorced Muslim woman can choose to apply for maintenance under both Section 125 CRPC without needing her ex-husband's agreement, unlike under Section 5 of the 1986 Act. Harmonious interpretation. Section 125 to 128 of CRPC and the 1986 Act operate in different fields and can coexist. The 1986 Act does not replace Section 125 CRPC, which applies universally and cannot be restricted to exclude Muslim women. Any interpretation excluding Muslim women from Section 125 CRPC would violate the constitutional right against discrimination. This interpretation aligns with Article 15 of the Constitution of India, ensuring non-discrimination based on religion or gender, and supports the spirit of Article 15(3), which allows for special provisions for women and children. Concept of maintenance. 1. Introduction to the 2019 Act. Section 5, Muslim Women Protection of Rights on Marriage Act 2019. Text of Section 5. Without prejudice to the generality of the provisions contained in any other law for the time being in force, a married Muslim woman upon whom talaq is pronounced shall be entitled to receive from her husband such amount of subsistence allowance for her and dependent children as may be determined by the magistrate. Scope. Section 5 provides that a Muslim woman who receives talaq-e-beddat, instantaneous and irrevocable divorce, can claim a subsistence allowance from her husband. Context. The 2019 Act addresses the issue of instantaneous talaq and provides the remedies for Muslim women who face this form of divorce. Right to maintenance. If a woman is divorced in a valid manner, she can seek maintenance under the 86 Act. If subjected to talaq-e-beddat under 2019 Act, she can seek maintenance under Section 5 of the 2019 Act. Next, maintenance laws and the 2019 Act. Two legal avenues. There are two legal avenues available to a divorced Muslim woman, both CRPC and their personal law, that is law of divorce for Muslim women under 1986 Act. The 1986 Act provides maintenance to divorced Muslim women under specified conditions. 2019 Act offers a remedy for talaq-e-beddat, focusing on subsistence allowance for women subjected to this form of divorce. Legislative intent. Objective: to ensure that Muslim women have access to economic support post-divorce, whether divorce was valid or invalid. Application of laws. Pre-divorce. A woman can seek maintenance under Section 125 CRPC or 2019 Act. Post-divorce. A divorced woman can seek maintenance under 1986 Act or Section 125 of CRPC if the divorce is valid. Next, broader perspective on maintenance and marriage, historical context and evolving view on maintenance. Siraj Muhammad Khan, Jan Muhammad Khan versus Hafizunnisa Yasink, AIR 1981, SC 1972. Observation: maintenance should not be viewed merely as charity, but as a right necessary for gender equality and legal protection for women. Current understanding: maintenance as a right. Maintenance supports women's right to financial security and equality, recognizing their contribution as homemakers. Legal protection: courts have emphasized that maintenance reflects the broader values of justice, equality, and human rights. Vulnerability of homemakers. Economic dependence. Many married women, especially homemakers, lack independent financial resources. Legal acknowledgement. Indian legal framework must support women's financial security, reflecting a shift from viewing maintenance as mere charity to acknowledging it as a legal obligation. Institutional and legal empowerment. Security of residence and financial independence. Prabhat Tyagi versus Kamlesh Devi 2022. Interpretation of domestic relationship. Courts have broadened the definition to include both current and past relationships for providing legal protection, including live-in relationships. Empowerment through maintenance. Financial security. The provision of maintenance is crucial for economic well-being of women who do not have independent sources of income. Family stability. Ensuring financial and residential security supports the broader societal goal of a stable family and consequently a stronger society and nation. Constitutional and legal support. Section 5 of the 2019 Act complements other legal provisions and underscores the intent of Parliament to provide comprehensive legal remedies for Muslim women facing divorce. Maintenance laws are integral to protecting women's rights and ensuring that divorce does not lead to financial hardship, promoting gender equality and legal justice. Now, here in this summary, we have attempted a detailed yet accessible overview of the 2019 Act, its relationship with other laws, and the broader socio-legal context of maintenance for Muslim women in Indian law.